Hearing the appeal, Republic of Mozambique, action for its Attorney General against Privinvest Shipbuilding SAL holding and others.
Yes. May it please the Court, I appear for the appellants in this matter, the Republic of Mozambique, along with my learned friends Mr. Blakely and Mr. Ferro. And for the respondents, Mr. Matthews, King's Counsel, appears with Mr. Wilmot Smith. As your lordships will be aware, the respondents are a group of companies called the Privinvest companies. They're D6 to D10, if I can refer to them in that way, and I will do during the hearing. Alternatively, as the Privinvest defendants. As the Court knows, as its handout says, this case concerns the so-called Mozambican tuna bond scandal, or hidden debt scandal, and it's arisen because the Republic's then Finance Minister, Mr. Chang, signed 3 sovereign guarantees on behalf of the Republic in respect of loans to 3 special purpose vehicle companies that were granted to those SPVs by 2 banks, Credit Suisse in 2 of the transactions and VTB in the 3rd. The guarantees your lordships will find in the bundle, I'm not going to turn them up for present purposes, from page 1579 and following. The facility agreements under which the loans were advanced by the banks to the SPVs, although the money was in fact paid directly to the Privinvest defendants, those are at page 1570 and following of the bundle. Now, as I said, the banks paid those proceeds of the loans directly to the respondents, or to 3 of them at least, D6, D7 and D8. They were called the suppliers under the supply contracts that your lordships will have read about. The money was paid up front and in full, direct from the banks, before any of the work under the contracts was begun. And that was essentially, therefore, the price payable by the SPVs under the supply contracts with those relevant respondents. You'll find the supply contracts, and we will look at them perhaps at them in due course, from page 1530 of the bundle. Now, just chronologically, my lords, the 3 transactions we're concerned with were entered into in 3 groups in around January 2013, August 2013, and May 2014. And the chronology may be of some relevance at some later stage in my argument and in your consideration of the issues. And the Republic's exposure under the guarantees, if indeed there is such exposure, would exceed $2 billion US. And I should say at this point, perhaps, my lords, that when I refer to a liability under the guarantees or similar, what I'm referring to is a putative potential liability. It's obviously an issue, and I don't want anything to be suggested otherwise. But I won't keep saying that if I can avoid it. My lords, it's now admitted by the respondents that one of them, that's D9, one of the 2 logistics companies as they're called, D9 and D10 are the logistics entities, in fact paid at least $5 million to Mr. Chang, or at least to a company affiliated with Mr. Chang, between October and December 2013. That's to say, after the first 2 transactions had happened, but before the 3rd had occurred. And your lordships will have read, I hope, and hoisted on board that those 3 transactions are known as the Pro Indicus transaction, that's the first one in January 2013, the Amartum transaction in August 2013, thereabouts, and the MAM transaction, which is the one later in 2014.
Yes, you can take it that the panel have read the judgments below, the statement of facts and issues, and the written cases of the parties.
I'm grateful, my lord. I shall not be developing the facts.
I'm not trying to silence you. It's just you're saying that your lordships will know. You can take it these things have been read.
I'm very grateful, my lord. Now, So as I said, focusing on the payments to Mr. Chang, who actually signed the sovereign guarantees, the respondent's case is that those payments were initially payments on account of investments of some kind in future proposed mutual business ventures. And it said that those ventures didn't actually come to fruition, so their pleaded position is that they were instead agreed to be used as campaign contributions to Mr. Chang's political campaign, and the reference for that, which you don't need to turn to, is Defence Paragraph 314 at page 1330. And the Republic's case, of course, is that those payments and other payments to the officials of the Republic were bribes. They'd been promised, we say, before the first transaction, on the basis that they would be added to the price payable, in other words, to the sums borrowed under the facility agreements, and therefore to the sums guaranteed by the Republic under the guarantee agreements. Now, some of the evidence for that assertion is recited in paragraphs 46 to 49 of the particulars of claim in their amended consolidated form that was before the judge and the Court of Appeal. That's at page 424. But for present purpose, I mention that merely because that being the form of the pleading before the judge and the form of the pleading that was considered by the Court of Appeal, that's the pleading on which I will focus my submissions. And it has been re-amended on multiple occasions, and your lordships have that in the bundle. And we'll perhaps see a bit of that in due course. But for present purpose, I'm focusing on the pleading that the judge had before him when he considered this application.
And do you accept that it is that pleading to which we have to have regard in determining the appeal? Principally, my lord, yes.
I think both agreed that the issues on the appeal can't turn on the precise form in which matters are pleaded. If the substance is different.
Well, there's plenty of case law pointing to substance.
Yes. But, my lord, why I said I essentially agree that one looks at the original pleading. Our case is that the substance of our case hasn't changed anyway, and if there are amendments to the pleadings that relate to matters that are relevant, if they elucidate the substance of our pleading, it's not wrong to look at them to understand what the case is or to identify the true nature of the dispute. But largely, my lord, we don't need to in my submission.
Thank you.
I should say, of course, they've moved on a lot since the pleadings that were before the judge, and the different claims have been introduced into those pleadings, including now alternative claims in Mozambican law responsive to the defendants pleading in their defence that Mozambican law governs the claims. No one has yet tackled the question of whether those claims fall to be stayed under Section 9, or whether they fall, if you like, in limine once with the outcome of the original Section 9, or whether they engage different issues. I'm not going to address that today. In principle, it's possible that one has to ask entirely separately whether Section 9 requires a stay of those claims. But I don't think that arises on this appeal, and I park it for now on that basis. It's now admitted, incidentally, because we are in that unusual situation on a Section 9 application under the Arbitration Act of having a fully pleaded defence from the defendants, that I think more than $100 million of payments were made by Privinvest to or for the benefit of Mozambican officials, and another $50 million or so was paid to the individual Credit Suisse bankers who are also defendants to the case. You'll see them referred to as the CS deal team defendants, D3 to D5. Now, I hope, as will be obvious to the court, the Republic's potential exposure under the three guarantees is the loss and damage that they seek against Privinvest. Of course, their primary claim in this action is to obtain a declaration from the court that the guarantee in the Pro Indicus transaction issued by Credit Suisse is either void, voidable, was avoided, or has been or can be rescinded. So its primary objective, clearly, is to ensure that there is no liability under the Pro Indicus guarantee. Different issues arise in relation to Imatum because of that transaction was converted from a security structure into a loan note structure. It doesn't particularly matter for present purposes. The MAM guarantee isn't the specific subject in terms of a declaration for voidness or non-liability in this action because VTB was the counterparty and VTB isn't a party to this case. There is a separate claim as between VTB and the Republic in which none of these issues have arisen.
Is there any claim for money that's been paid out, or is it all being paid out by Credit Suisse? Is that where the loss will fall?
Yes, my lord. It was all paid out by Credit Suisse, as I said, up front, straight to Privinvest, under the facility agreements. And if therefore the guarantees are void, and the repayments by the SPVs have not been made, which they have not, in large part, in a very significant part, I think, then the loss will fall on Credit Suisse in the first instance in this case. Yes, that's.
So why does this claim that we're here dealing with matter?
Well, my lord, it matters in one serious respect, which is that if my client's allegations are correct, then Credit Suisse and Privinvest jointly bribed my client's officials to the tune of to enter into the guarantees and paid them over $130 million. Those claims are claims the Republic has in restitution for the sums of the bribes. And the only other, the other way in which it matters, my lord, is of course, were there to be liability under the guarantees, if for some reason, notwithstanding the facts, Credit Suisse can establish that the pro indicus guarantee in particular is not void or invalid, then of course we may be liable under it, and we would seek an indemnity or damages for that loss represented by the liability from Privinvest, amongst others. The other angle, of course, to which why this matters to my client in a less obvious and direct way, I suppose, apart from the enormous amount of what we say with the bribe payments, is the macroeconomic loss claim that is made in this case. Because the claim here is that the foisting, if I can put it that way, of the guarantee liability, potential guarantee liability on the Republic of Mozambique has created an enormous macroeconomic loss, because apart from other things, it's engaged difficulties with the IMF and other lenders, and has had what we say is as we plead, a very significant impact on the Republic's economy on a macroeconomic scale.
And is any of the Privinvest companies a substantial company with assets?
Well, we don't know that, my lord. My primary submission would be it's not particularly relevant.
No, it isn't relevant to the law, but some
we hope
relevance
so.
still.
We hope so. They did receive billions of dollars of proceeds of the loans, which were guaranteed, and we say the SPVs received in return very little of value. That's an issue, but somewhere that money has gone. Now, your lordships will see that the claims are not just against the Privinvest corporate entities that are the parties to the various contractual arrangements. They include also Mr. Safa, who is we say, the principal behind the Privinvest entities. All of the same claims we make against the Privinvest entities are made against Mr. Safa on all the same bases. But of course, and those actions are not subject to any Section 9 application or anything like that, because there was never any contract with an arbitration clause between the Republic and Mr. Safa. But the impact, the reason this is aptly called the tuna bond scandal, my lords, is that this has led to this effect in the international banking sector, that Mozambique has been unable to borrow money, the IMF, it's been in trouble with the IMF, and the costs of its borrowings and so forth have been inflated. Those are all issues in the main action. I hope you'll have seen that the main action, the trial of the liability claims, is to take place this October in front of, I believe, Mr. Justice Knowles in the Commercial Court. And that trial is going to decide the other element of the present application that's now reached your lordships, which is whether whatever the scope of the arbitral agreement and whatever disputes it might cover, was the Republic in fact even a party to them? Because so in a sense, the entire issue for your lordships is potentially rendered academic if it turns out that the Republic was never a party to the arbitration contracts.
We're being told to proceed on the basis that, on the assumption that the Republic was.
Yes.
But are you saying that issue is being tried?
Yes.
In October?
It is.
So when you speak about liability, the issue is whether or not the Republic is bound by the arbitration.
And that includes that issue.
Includes that issue.
As well, of course, of all of the issues about whether the monies that we say were bribes were in fact something else, and the amounts of them and who paid them and all of those sorts of issues. And
there's been no application to try to stay any of that, or has there?
No, my lord, not beyond this application.
No.
So the reason it's arisen in a slightly curious way is because the issue of whether the Republic is a party to the arbitration agreements, despite never being a signatory or a named party, involves many of the same issues on which liability will turn at the trial. In particular, it involves questions of whether the parties were acting in good faith towards one another. And we say, as a matter of Swiss law, if it's correct that Privinvest were guilty of bribery of our officials, then it will not lie in their mouth, as a matter of Swiss law, to claim that we became party by operation of certain Swiss law principles to the arbitration agreements, because they wouldn't have been acting in good faith.
Yes. But so, standing the ruling of the Court of Appeal, which you're challenging, that everything goes to arbitration, how is this liability trial to take place?
Well, my lord, the position at the moment is that everything the Court of Appeals decides, and that which your lordships will decide on scope, is subject to the outcome of the party's decision that will happen at the trial. Therefore, there are two outcomes, obviously, potentially. At trial, it's decided that the Republic is not a party to the arbitration agreements at all.
Yes. Because
the operation of Swiss law my learned friends rely on doesn't work. And then I'm afraid to say that the issues that your lordships will have decided, and so far have been decided by the Court of Appeal, will fall away. They'll have been academic.
Yes.
On the other hand, if the court does decide that that my client became a party, then the true ambit of the stay, the matters that won't be decidable in the commercial court trial, will be decided by the scope issue.
Thank you.
Now, they will already, in a sense, have been decided, because the trial will itself decide, as against at least those who are not parties to the arbitration agreements, whether the claims in bribery and conspiracy and dishonest assistance and so forth have been made out. That will apply against Mr. Saffer in particular, but also Credit Suisse. And it's important to bear in mind that Credit Suisse are, on our case, jointly liable for those causes of action too. They're liable in bribery and conspiracy and so forth. We'll come on to that in a little more detail. But the upshot, my lord, is that the decisions on the facts at the trial, depending on the way the parties issue falls out, and obviously the way the scope issue has been decided now, will the factual issues will then have to be applied according to the findings on parties and scope, and there either will or not be binding decisions in relation to liability between the Republic and certain of the Privinvest defendants, depending on the outcome of that question.
So assuming the decision stays as determined by the Court of Appeal, what exactly are the liability issues then? I mean, they are involving Saffer and Credit Suisse.
Yes. If it
as far
stays
as the defendants were concerned with,
yeah.
As things stand, no liability issues against them, subject to the
yes,
party point.
Yes, so the irony, my lord, is that those issues will all have to be tried out as if in full issue and
well, not all of them, presumably. But the only issue as far as those defendants is concerned at the moment is whether they're part of the arbitration agreement. Is that right?
Yes, but because the answer to that, my lord, won't be decided until the end of the trial.
Quite.
The trial will have to decide the trial will take place as if they're all engaged, all issues are engaged. The
So really findings, you mean?
Yes, there will have to be findings as to what happened, because that will be necessary not just for the liability of Mr. Safar, but also the liability of the Privinvest defendants in the Part 20 claim, because they are defendants brought in as Part 20 defendants by Credit Suisse. And all of the very same issues that we're talking about today will have to be tried between Privinvest and Credit Suisse in any event, and decided, because there is no arbitration agreement argument between them. So it's a long and complicated way of saying to your lordships that these issues will all have to be decided on the facts, but the question of the extent to which they're binding on the parties will depend on whether they are in fact found to be parties to the same arbitration agreements.
And how long is the trial down for?
13 weeks in October, so the full Michaelmas term this year. Now I should mention for that reason that obviously your lordship's decision on scope has one potential importance. If your lordships were to overturn the court's decision, as I invite them to, then the issue of parties would fall away, because it wouldn't matter. And so the Swiss law issues around the concepts of becoming a party to an arbitration agreement by the doctrine of interference, for example, which is what it's called, or by the beneficiary principle, if I may say, a bit like our Third Parties Act. Those would not be live because it wouldn't matter who was parties if the disputes weren't in scope.
But if you succeed either wholly or partly, the trial will still go ahead. It wouldn't go off in any sense.
No, my lord, I think I can say the outcome of today will not make a difference to what actually happens at the trial, except whether that Swiss law issue of the parties needs to be raised. It is a very curious procedural situation that we've arrived at, and that's why we have said, and we continue to say, that there is no for the Privinvest defendants, there's no getting away from a trial of these issues. It's going to happen, both because of the parties' point being one decided at the trial, and because Privinvest are alleged to have all the same liabilities in the Part 20 claims brought by Credit Suisse. And thirdly, because Mr. Safar's position is as I've described it. Now, with that, that's the picture. I hope, in my submission, it is obvious that the Republic's potential exposure under these transactions is therefore solely and exclusively pursuant to the guarantees. They were the only contracts the Republic was a party to, on its case, a named party, and the only ones that were signed on its behalf by, in this case, Mr. Chang. Now, whilst there is the issue that the respondents allege that we became a party by operation of Swiss law to be tried at the next stage, it is relevant and important, my lords, I would submit, that's denied by the Republic. And when you're considering what its claims are, what the Republic's claims are, they are predicated on it only being a party to the guarantees. And its interest is only in holding the bribers, the alleged bribers, liable either by way of indemnity or in a claim for loss and damage, and in restitution for the amounts they are alleged to have bribed our officials. Now, I do say that our interest is in holding the alleged bribers liable, and not just the Privinvest parties, because as I made clear, the alleged bribers in our case include both Privinvest and Credit Suisse. There is no distinction between the two as far as we are concerned. We say they are jointly liable, joint tortfeasors in bribery and in conspiracy. And you'll see that if you look at para 131 of our pleading and page 442, and the description of the loss we claim at 154.1 at page 448. And in that regard, my lords, it may be worth me pointing out at this point as well that the conspiracy claim we bring, also against both Privinvest and Credit Suisse for joint liability, includes the bribery by Privinvest of Credit Suisse's officials. mainly just to test the system perhaps, but just so that your Lordship can see it. If you go to page 442 of the bundle, paragraph 133.1 of our pleading, you'll see the bribery case.
Sorry, could you give the page again?
441, my Lord, on to 442.
Paragraph
129, and then in particular 131 on top of 442. The point, my Lord, is a simple one, that we say that as part of the conspiracy, well, let me start again. You'll see at 129 and 441 that the bribes we understand to have been received by the Credit Suisse people and the Mozambique officials are set out in Schedule 2. And that sets out, at 458, the various amounts that we had, at the point of which this pleading was prepared, identified as the bribes. And you'll see at the bottom of page 458 that we'd identified that Mr. Pierce had received $45 million, Mr. Singh $4.5 million, and Ms. Sabeva $2.2 million. Now those, of course, are payments not to our own officials, but to the Credit Suisse employees or agents. So whilst it's correct that we don't have a bribery claim against Privinvest in respect of those sums paid to the Credit Suisse individuals, because they weren't our agents, not our fiduciaries, we do, as an important part of our conspiracy case, have a claim, the unlawful means of which includes the bribery by Privinvest of the Credit Suisse agents. Now the respondents, Privinvest, essentially...
But not a claim for those sums?
Not a claim in restitution for those sums on our part, my Lord, but a claim for the loss flowing from the potential liability under the guarantee, under the conspiracy claim that is premised on an unlawful means of bribery of the Credit Suisse officials.
It's unreal, isn't it, to think there'll be a claim under the guarantee if it was procured by bribery?
One hopes so, my Lord, but it's...
I mean, I know you want to be cautious, but there are limits to what's realistic.
Well, that will be music to people's ears on this side of the court. But, my Lord, these are all issues heavily in dispute. There are all sorts of reasons why Credit Suisse say that none of this matters because the knowledge of their employees can't be imputed to them, and there are an infinite number of ways in which the banks are defending these proceedings. So I take your Lordship's point. But it is important in my submission to bear in mind that we could bring a conspiracy claim in this case solely based on that unlawful means. That unlawful means really has nothing to do with the supply contracts, because the Credit Suisse was not party to the supply contracts and isn't alleged to be party to the supply contracts. That unlawful conduct on that particular head of the unlawful means conspiracy engages only the guarantees and possibly the facility agreements, no matter how you cut it. And as I said, my Lord, those payments are essentially admitted to the Credit Suisse officials. They're said to either be for consultancy services unconnected with the projects, or remuneration for legitimate services in relation to the projects through a firm that they later together established. That's Privinvest and the CS-Deal team defendants, called Palomar. And you'll see that explanation for those large sums at paragraph 334 of the defence on page 597. I'm slightly digressing, but it is important that the court is aware of the full panoply of the wrongdoing that is encompassed in our claims. Now, coming back to the point I was on a moment ago, it is for all of those reasons that the Republic, because the Republic does not accept and never has accepted that it's a party to the supply contracts, that its case is and has to be premised solely on the fact that it was a party only to the guarantees. It can't run a case that it was or might be liable or entitled on the supply contracts. And that is the prism through which one must seek to understand the substance of the claims that are brought in these proceedings. whatever Privinvest now say that the Swiss law position might turn out to be. And of course, we are considering in this appeal what under Section 9 are so-called matters in respect of which the proceedings are brought. Those are essentially the words of Section 9 that one is required to construe and apply. And in that respect, it is relevant in my submission that on the Republic's case, it is impossible for the Republic to claim rescission of the supply contracts, for example, or to make a claim for breach of the supply contracts, claim damages under them, because it was never a party to them. And in a sense, it would also be rather pointless for the Republic to make claims in respect of or under the supply contracts, because it certainly did not borrow the money. The money was borrowed, as you know, under the facility agreement by the SPV companies, which have separate legal personality. And the Republic, therefore, didn't pay any money under the supply contracts either. That's why it's quite wrong, in my respectful submission, for my learned friends to continue to mischaracterise our case as being centred, as they put it, on the supply contracts. You'll see that, for example, in their written case at paragraph 16. Now, in your printed copies, that's at page 78 of the bundle, my lords. It's at page 99 electronically. You'll see there the respondents say that the Republic alleges in these proceedings various causes of action against, among others, the Privinvest defendants. Its claims are considered in more detail below. And then this. Its central claim, it is said, is that the supply contracts were not genuine commercial contracts. Now, my lords, that is certainly not our central claim. It couldn't be, and it wouldn't assist us if it were, because our only source of potential liability in this package of transactions, the only source of any potential loss, is in fact our liability under the contracts of guarantee. And if you go perhaps to para 17 of the defendant's written case, the respondent's written case, at page 79 in hard copy, page 100 electronically, you'll see the next submission is that it is said that the Republic seeks a range of relief against the Privinvest defendants, the broad effect of which is to avoid liability for the cost of the goods and services contracted for and in large part received under the supply contracts. Now, the telling words in that submission are, of course, broad effect, because it's only by mischaracterising the range of relief we actually seek, or at least treating it, I suppose, at such a high level of generality that it's meaningless as a matter of analysis, that you can even say what is said in that sentence about our case. As I said, it ignores completely the tripartite nature of the contractual arrangements and the separate legal personality of the borrower under the facility agreement and the customer under the supply contract, which was in each case the SPV. But what is our central case? As I've said, it has to be that the bribery of the officials of the Republic by Credit Suisse and Privinvest exposed the Republic to liability under the guarantees. And by bribery, my lords, I mean, of course, the English law concept of a promise or payment by a third party of a benefit to an agent of the Republic acting as such. I suppose that's to say, to an agent acting in some respect on behalf of the Republic in the relevant dealings surrounding the contracts, which is kept secret from the Republic. And in that respect, I don't think I need to take your lordships to it. That is a classic statement of the English law of bribery, made first by Mr. Justice Leggett in An Angel Atlas, which is a case you'll see quoted, which is a dictum you'll see quoted at paragraph 105 of Mr. Justice Christopher Clark's judgment, as he then was, in the Noviship case, electronic bundle 2795. As I say, I don't perceive there to be any dispute between me and my learned friends as to the ingredients of the English law claim in bribery. Might I just mention at this point something I have already alluded to? Of course, when we had the debate about this issue before the judge at first instance, we had only pleaded a case in English law. And in the rather unusual circumstances of the way this case has developed procedurally, we now have a very fully pleaded defence to those claims by the defendants, despite their stay application. And Privinvest, the respondents, introduced as an issue whether, in fact, the claims against them were or should be governed by Mozambican law. And you'll see that in their defence at para 449.1 at page 649, where there is a whole, for example, that is in relation to bribery, it is said in terms that the claim is governed by Mozambican law, and there is no such claim under Mozambican law for various reasons, not least because they say these sorts of payments to these sorts of people for the sorts of purposes they allege do not breach Mozambican criminal law. That's 449.2.2.
Well, now that that's been introduced, it must be right, mustn't it? They are governed by Mozambican law, these claims, not English law.
Well, no one would. We say not. And in any event, we say it doesn't matter for present purposes. We plead in return, we've amended our case to say we deny that Mozambican law applies for various reasons. But in the alternative, in the usual way, we have pleaded alternative and additional claims in Mozambican law were we to be wrong on that question. And we plead those alternative Mozambican-style bribery claims at paragraph 151A and following of our re-amended particulars, which you'll see at page 1179. And so in a sense, or in essence, in fact, there are now two sets of claims pleaded, one claim for bribery in English law, and one claim for an alternative claim for bribery and conspiracy and so forth in Mozambican law. And the parties have engaged on the relative issues of Mozambican law too. But my Lord, in a sense going to my Lord Legate's point, there are two matters that arise, I suppose, at that point. The first is that the Section 9 application is only made in respect to the English law claims, and I'm not taking a point on how one therefore deals with the Mozambican law claims for Section 9, but I'm simply saying that the issue before the court, decided by Mr. Justice Waxman in the Court of Appeal, is on the basis of an English law claim in bribery and conspiracy, and that's what's before your lordships today.
What does the Credit Suisse defendants say about applicable law?
Yes, I believe, and I hear comments to the effect that they do not claim a different law than the one we allege applies. So they go for English law. I'll try and get you a reference to that if I can.
The English law can arise either because nobody pleads a different law by default, or because the proper law is in dispute and it's decided to be the applicable law.
Oh yes, I'm rightly pointed out, I should have said this, that as against Credit Suisse and the Republic, of course, the guarantees are governed by English law and have an exclusive English court jurisdiction clause. But as for their claims equivalent to ours against Privinvest in the Part 20, as I understand it, they simply plead them out as following ours in English law. What's interesting, perhaps, my Lord, is that one may say there is a case that Mozambican law does govern, but what is particularly interesting is that the Privinvest defendants do not allege that Swiss law governs. Now, Swiss law, of course, is the governing law of the supply contracts. So if the bribery and conspiracy claims were as sufficiently connected to the Swiss law supply contracts as Privinvest say on this application, one might well ask why they in fact accept that Swiss law does not govern the claims against them, but instead they're governed by a wholly different law, Mozambican law. And we say that is a reflection of the inevitable fact that, leaving aside their position in this application, There is in truth no proper connection, or no sufficient connection, between the claims we make for bribery exposing us to liability under the guarantees, or for restitution of the bribes, and the supply contracts, that they are genuinely not governed by the governing law of the supply contracts precisely because there isn't a connection, or a sufficient connection at least. My Lord, it's just interesting that perhaps as an aside here, and I don't want to go down a long rabbit hole, but it was the Privinvest's case at first instance on this application that claims for pre-contractual bribery was culpa in contrahendo in the civil law parlance, and gave rise, as a matter of Swiss law, to a contractual claim once the contract had been concluded that had been tainted by the bribery, and the concept in that respect is known as the absorption theory of under civil law systems. And I'll just give you a reference to where Mr. Cowell, the Queen's Counsel, as he then was, made that submission. It's page 236 of the bundle, at first instance, page 12 and lines 1 to 5 of the transcript. And of course that was based on evidence that he'd elicited from a Swiss law expert, who had said in terms that a claim for bribery in culpa in contrahendo as a matter of Swiss law is absorbed into the contract and becomes a contractual claim. Now, for various reasons, that whole issue of culpa in contrahendo was never fully developed, and the Court of Appeal rightly decided that it couldn't decide this case on it. But it's telling in my respect, my lords, because, of course, if one were to apply Rome 2 to a civil law culpa in contrahendo claim, as the absorption theory itself tells you, if you like, Rome 2 dictates that it's governed by the law of the contract to which it is connected, which would have to be Swiss law. My learned friends... I don't
understand why any of this is any relevance.
Well, my lord,
claim that they haven't advanced in Swiss law.
Because
they're not advancing now.
Because, my lord, on one hand, they say the claims we bring are sufficiently connected to Swiss law to fall within the arbitration clause in the contract. But on the other hand, they say the claims are not sufficiently connected to be governed by the very law that contract would require them to be governed by.
Well, you can often have claims governed by a foreign law within the scope of an arbitration clause.
It's possible, my lord, but it doesn't work on the very theories that were advanced by my learned friends below to try to argue that these claims were sufficiently connected to the supply contracts. By reference, for example, to the theory of bribery under Swiss law and the absorption concept. But my learned friends are, therefore, trying to have it both ways before this House, before your lordships, because they're inviting you to find that they're sufficiently connected when they don't say that themselves when it comes to the analysis of the governing law. Anyway, it may be something of a digression, and it's not legally determinative, my lords. But it does, in my respectful submission, serve to demonstrate what's at the root of this appeal, the issue on this appeal, which is ultimately a factual one in the sense of a foreign law application to the words of an arbitration agreement. It does, in my submission, serve to demonstrate the artificiality, to use their expression, of the idea that there was a sufficient connection in that sense. Now, my lords, it might also be relevant to note that the respondent's defence to the tort claims in bribery and conspiracy is essentially to plead that, as a matter of Mozambican law, the payments that were made, and most are admitted to have been made, were legitimate so that no Mozambican law crime was committed in their payment, as I've mentioned. You see that most clearly pleaded at para 366 of the defence, page 609. So what's important to note by reference to that, of course, is that it is in fact no part of the Privinvest's defendant's actual defence that the supply contracts have got anything to do with the tortious claims in bribery, even under the law they say governs. So we're not, of course, in a world which is the normal world for Section 9, where one is imagining foreseeable defences or contemplating intimated defences that have been advanced in the evidence on a Section 9 before the pleading. We're in the real world here, where we actually know the actual defence that's being put forward to the claims under the governing law that they posit, which is Mozambique. And that actual defence has nothing to do with the supply contracts, as far as the tortious claims are concerned. And yet, from first instance to now, my learned friend's case is that is what this case is all about, because that is their defence. They will raise a defence by reference to the validity, etc., of the supply contracts. So I suppose one could summarise the position at that point in this way, that I'll come on to deal with the English law claims in bribery and make the point that under English law, the supply contracts cannot offer any relevant defence at all. They're utterly irrelevant. But even under the law they claim governs, they are also irrelevant, and they're not pleaded as relevant at all. So why are we here arguing about the supply contracts being sufficiently connected to the bribery claims that they must be arbitrated? Now, can I go back to just a couple of points on the English law of bribery, because I'm going to now deal squarely with the claims we did advance and were advancing before Mr. Justice Waxman at first instance. One, of course, if you want, is to apply the Section 9 test to understand what are the matters in respect of which these proceedings are brought. One has to analyse the cause of action. Now, we'll come on to whether the degree of granularity of that exercise, which is one of the vexed questions under the authorities. But one can certainly say, in my respectful submission with confidence, that the starting point has got to be to understand the legal framework and relevance of the issues that the parties are raising. Now, if the claimant, as I've said, can establish that a secret benefit was promised or paid to an agent as such, that benefit gave rise to a realistic prospect of a conflict of interest between the agent's personal interest and the principal's, and that it was kept secret from the principal, that will amount in English law to a claim in bribery. Both a tortious claim in bribery, damage normally being presumed in the amount of bribes, although that is a rebuttable presumption, I perceive, but also a claim in restitution for the amount of the bribes. In the alternative, of course, you can't have them both. And for that purpose, damage is irrelevant. So there's four legal propositions, my lords, that flow from our case on bribery. One, there doesn't need to be any linkage between bribery and a particular contract. Indeed, the authorities are clear that there doesn't ever need to be a contract ever entered into. The cause of action is complete, and the bribe can be required to be disgorged in restitution merely upon the promise of it and then the payment of it over to the defendant. It's entirely irrelevant what contract, if any, flows. If, however, this is the second proposition, a contract does flow and one is subsequently entered into, whilst the realistic prospect of conflict subsists, that's to say, whilst the bribe is capable of influencing the mind of the bribee, the recipient, then of course the principal can rescind that contract, assuming it's still possible to do so under the normal principles of rescission and restitutio in integrum. And for those purposes, my lords, it's entirely irrelevant whether the contract was on commercial terms, on market terms, or even better than market terms, or profitable. And it's also entirely irrelevant, certainly for the restitutionary claim, whether the contract would have been entered into anyway, even if the bribe hadn't been paid. And the third proposition, and I do apprehend none of these are in controversy as far as English law is concerned. The third proposition is there is no need on the part of the claimant in my client's position to prove dishonesty or fraud, because English law irrebuttably presumes that an arrangement of the nature I've described is dishonest. It is the tort of fraud, as it's sometimes called. So it is utterly irrelevant from my perspective to seek to set out that the Privinvest defendants had some kind of intent or dishonesty, because English law will presume it irrebuttably. And then the final point, therefore, is that there's no need to prove intention on the part of the payer of the bribe to influence the agent. There's no need to prove any causal link is intended between payment and outcome. And there's no need either to prove that it did influence the agent. My lords, those four propositions are, as I say, uncontroversial, and you'll get them from the overview of the law by Mr. Justice Christopher Clark, as he was in Noviship, at paragraphs 106 to 111, which is in the bundle of page 2796 to 7. And I won't, therefore, take you to them because they should be uncontroversial. Now, that leads to the next stage of the argument, my lords, which is where a key issue in both of our grounds of appeal comes into focus. And the upshot, the nub, as is perhaps obvious, is that for our claims against Privinvest and Credit Suisse in bribery, it is not legally relevant whether the supply contracts were entered into, whether they were commercial, whether they were uncommercial, valuable, not valuable, profitable, not profitable, in the Republic's interests or not in the Republic's interests. Those matters are all genuinely irrelevant as a matter of law. However, the Privinvest position on this application, in their defence, is that they intend to seek to prove the commerciality, honesty, validity, profitability, whatever, of the supply contracts as a defence. And you'll see that perhaps most clearly, perhaps if you look, my lords, at paragraph 26, sub 4 of the Privinvest case. It's at page 85 of the hard copy or page 106 of the electronic version, the electronic call. And you'll see at the end of that paragraph, subparagraph, it says the Privinvest defendant's case on liability. This is internal page 12, hard copy 85. The bottom of sub 4. The Privinvest defendant's case on liability rests upon, amongst others, the claims that A, the supply contracts were commercial and commercially valuable, B, entry into the supply contracts was in the Republic's interests, and C, the provision of the guarantees backing the facility was the only way the Republic could afford and finance the purchase price, and the precise financial options agreed by the Republic for the Republic. Now, my lords, that may be what their case on liability does indeed turn upon or rest upon, but if it does, it will not afford them any conceivable defence to the claims we bring against them. And I repeat, because it's potentially important, that they don't even raise these allegations as a defence to the Mozambican law claims that they claim are the proper claims against them, or the claims are governed by Mozambican law. So the first point to note, of course, that we say at this point, is that the stay application in respect of the bribery claims is indeed be dismissed, Section 9 application, because there is no legal relevance to any issue arising from or in connection with the supply contracts to our bribery claims. End of story. That's the bribery claims. My lords, it would equally be irrelevant as a matter of English law to our conspiracy claims to prove that the supply contracts are valid and honest. And I'm focusing here solely on the conspiracy that involves the unlawful means of bribery in the first instance. I'll come on to the other unlawful means in a moment. But clearly, if it's not a defence in law to assert the validity or commerciality of the supply contracts to the claims in bribery, it is equally not going to be a defence to an unlawful means conspiracy claim where the unlawful means alleged are those very instances of bribery. Just legally irrelevant. And insofar as there is an element of intent to the claim of conspiracy, of course, the dishonesty, the intent to be fraudulent, is irrebuttably presumed by the finding that there were bribes in the first place. So that disposes of the conspiracy claim as far as it includes the unlawful means of bribery. But insofar as the unlawful means are other things altogether, my lords, perhaps we could just call up on the screen page 442 of our pleading, where you'll see the allegations of unlawful means, because there's some importance to a lot of these. You'll see that there are various of those unlawful means, 133.1 to 133.6 over the page, such as Credit Suisse's own wrongdoing in entering into the guarantees. That's 133.2, when it knew what we say it knew about the bribery. And then over the page 133.6, the unlawful means alleged are deceit by Credit Suisse, and only by Credit Suisse, at paragraph 143 of the pleading, which you'll have to look at lower down, if you were, in the pleading. But that's an allegation of deceit in 133.6 that is only made against Credit Suisse. And you'll see that from page 445, paragraphs 143 and following. It's in relation to the Martin transaction and guarantee. Now, those claims, of course, the conspiracy to use those unlawful means to damage the Republic, taken on their own, assuming they're the only two unlawful means we were to advance, have not only no legal connection to the supply contracts, but no factual connection to the supply contracts at all, because Credit Suisse wasn't a party to them. And so, on no analysis on any of those unlawful means, and the only one that matters, in inverted commas, for today, is the third unlawful means that we plead, 133.3, which is the IFA, the instrument of fraud allegation, which I'll come back to. But taking that out of the equation, looking at the others, you'll see that there is absolutely no connection possible, legally or factually, to the supply contracts in the conspiracy claim either. Now, of course, dishonest assistance we plead as well. In a way, that is simply the equitable corollary.
Just before we go on to that, I mean, but you say take it out of the equation, but that claim is still there.
Yes, and can I come on to deal with that as a topic on its own?
Yes.
It's obviously an important one.
It is an important one.
And I want to explain why it's there, but it's not there for relevant purposes, if I can put it that way. And it arises largely because of the convoluted way in which we've arrived at the position we are today. I'd like to address that in a block, because it's slightly complicated and very important. But I was going to mention the dishonest assistance claim. I may come back to that. It's the corollary of the bribery claim in equity, essentially. And the dishonesty is supplied by the fact that the bribes were paid. And one is therefore left asking, what are the acts of assistance? There may be a factual connection to a supply contract in that regard. I'll come back to why. But we say that doesn't drag the whole claim for dishonest assistance into the arbitration clause within the supply contracts for reasons I'll expand upon later. What one can say with a degree of confidence in my respectful submission is that looking at the two key claims in this case, the bribery and the conspiracy claims, there isn't any warrant for the assertion by Privinvest that were it to set out the case I've just shown you on liability, it would amount to any defence in law to any of those causes of action, any of those claims. And that is where, my lords will appreciate, we say the Court of Appeal went wrong in the most obvious way, because the Court of Appeal assumed that they were and would be relevant defences and simply took that at face value with no real analysis in the core of their decision. So perhaps that's the point at which I could ask your lordships to look at the Court of Appeal decision to see what this error we respectfully submit they fell into is.
Just before we go there, where's your pleading on dishonest assistance?
My lord, that is over the page at Roman 5, 444 of the bundle, paragraph 137. And the debate focuses on the third element of the assistance allegation, which we say was the entry into the supply contracts as a matter of fact. We say that does not engage an issue that requires to be arbitrated about the supply contracts. We're simply saying that but for that factual act, which is undisputed, at least some of the Republic's officials' breaches wouldn't have occurred, that it assisted them in fact. And it assisted them in fact, of course, I hope this is obvious, because the payment, when one has the promise of bribes, then the transactions happen, the cash flows through from the facility into the hands of Privinvest, and then the promises are made good on. And there's a breach of duty on the part of the officials at the point both when they act under the promise of bribes in a corrupt way, but also, of course, a separate and additional breach when they receive the cash that the bribes amount to. And it is simply a question of fact, we say, that the entry into the supply contracts and then the entry into the facility agreements, in reverse order, as it were, assisted the payment of the bribes. That was the route through which the cash flowed. So that's the reason we say the dishonest assistance claim doesn't engage issues that are arbitral under the supply contracts, and I may well come back to that. My Lord, there's also a claim for knowing receipt, which really is irrelevant for today, because we don't have any actual allegation of a sum that we say was received in the relevant sense against the Privinvest defendants. Now, a lot of hot air and angst has been expressed over that. The reality is, if there's a point here on knowing receipt, it's a strikeout point, not a Section 9 stay point. But for present purposes, my submission is you can ignore the knowing receipt claim for today. Now, I would like to show you, if I may, the Court of Appeal decision and make good my submission that the Court of Appeal fell into the very error that my learned friends are now falling into. I hope your Lordships have got that in your key documents bundle, but it's the relevant section. Perhaps we could start at tab 5, page 126. It's page 764 of the electronic version of the core bundle. I start there because the Court of Appeal identifies the issues on the appeal at the bottom of the page. This is Lady Justice Carr in the decision, as my learned friends repeat, a unanimous decision of the Court with Lord Justice Henderson and Lord Justice Singh. And the two issues are identified there at 5.1 and 5.2. And just so we clear that out of the way, the appeal was dismissed on ground 1, and the Court of Appeal upheld the judge's findings and conclusions in relation to the Swiss law construction approach to arbitration agreements, if I can put it in that way, but allowed the appeal on ground 2, which was whether the claims actually fell within the scope of the agreement at all. Now, the key part of the reasoning I'd like to show you first is at paragraph 96, please, page 150 of the hard copy and 788 of the electronic copy. And conveniently, we're under ground 2, you'll see at para 83 on page 785, but starting at the top of page 788, what I'm doing, I'm going to show you the Court of Appeal's decision having skirted over the IFA point, which I'm going to come back to, my Lord, on, because I just want to focus on the analysis of the defence and law to the allegations of bribery. And so you'll see that Lady Justice Carr starts 96 with the comment that even with the IFA effectively removed from the pleaded claim against the Privinvest companies, the validity and genuineness of the supply contracts are matters bound to be relied upon by the Privinvest companies, at least as part of the defence to allegations of dishonesty maintained against them. At the very least, it is reasonably foreseeable there will be issues raised by way of defence, and then she says they're substantial, etc. Now, can I just first of all note, and bank, if you like, for the IFA part of the argument, that my lady does in fact accept at paragraph 96 that this analysis flows at the beginning once one has treated the IFA as having been effectively removed, which is what we say has happened by virtue of the concession we made and the decision the Court of Appeal reached in upholding it. That's for the next part of the argument. I just wanted your Lordships to see that. the first thing to note about paragraph 96 otherwise is this is the comment that the validity and genuineness, etc., of the supply contracts, including the circumstances surrounding their entry and performance, are matters bound to be relied upon by the Privinvest companies in their defence. Now you see that footnote 12 at the bottom, which is a reference to Mr. Matthews' answer to Her Ladyship as to, in what I hope is fair to characterise as a relatively leading question from the court, made during the reply submissions in the Court of Appeal. And you'll see that the actual exchange between Her Ladyship and Mr. Matthews at page 225 of the bundle, transcript A2, page 102, but that's an aside. Now, pausing there, it's clear, my lords, that the Court of Appeal, that Her Ladyship did not consider or analyse anywhere before making that statement whether an attempt by Privinvest to rebut dishonesty or anything else relevant to a defence by reference to the supply contract would in fact, or in law, even amount to a defence at all. There is no consideration of that issue in the judgment and no analysis of how it is supposed to work. And for the reasons I've already given, it is utterly irrelevant, both to the wider issues in the bribery claim and because dishonesty is presumed and irrebuttably presumed, no matter what, upon the proof of bribery. So it follows, my lords, that the next sentence of paragraph 96, where the court says they are substantial and not peripheral matters, the supply contracts, etc., that's a non sequitur, because they can't be substantial matters in respect of which proceedings are brought if they have no potential legal relevance in the proceedings. And incidentally, of course, and one sees that the reason the court gives for the absence, or for the substance and non-peripheral nature of the allegations is that they were the only contracts the Privinvest companies entered, and they were an integral part of the suite of the contract connected transactions. My lords, that can't be a legally relevant point for the purposes of a Section 9 application, because the substance and peripherality of issues and matters for Section 9, particularly the question of whether proceedings are brought in respect of them, must involve the analysis and the establishment of legal relevance as a sine qua non to them being matters in respect of which proceedings are brought. And the fact that these happen to be the only contracts, as he said, Privinvest entered, can't make up for any of that if they're of no legal relevance. One might as well refer to any other contract Privinvest entered. And that problem in the Court of Appeal's reasoning, or the lack of any analysis of how issues that are legally relevant might be illuminated by anything to do with supply contracts, infects the first sentence of paragraph 98, where the court says that at the first stage of the exercise, the matters in respect of which the proceedings are brought against the Privinvest companies include the question of whether or not the supply contracts were valid and commercial contracts, genuine commercial contracts. It cannot be correct in my submission that the matters in respect of which the Republic brings these include issues raised by a defendant that are legally irrelevant, even if factually established.
So you say it's evidentially relevant, but not legally relevant?
Well, not even evidentially relevant.
You say not even evidentially relevant?
Well, in order to be take the bribery case, in order to be evidentially relevant, they would have to establish something that tended to prove or disprove one of the constituent elements of the cause of action, or to provide a defence. But for the reasons I've outlined, when going through the elements of the cause of action, there are virtually the only defence to one of these claims is either the payment wasn't made, or the agent wasn't acting as such, or there was no secrecy. Otherwise, if you accept the payment was made in English law, you are both liable in bribery and irrebuttably dishonest. And So no attempt to prove that the supply contracts were good, bad or ugly can even evidentially be relevant, let alone legally in the required sense that would make these proceedings brought in respect of that matter, which is the relevant point for Section 9.
So you say the second sentence in 98 is neither here nor there. It's not what you have to prove. You say the focus should be, is it a relevant defence?
Yes. Could it ever be relevant, my lord? Is I can put it that high,
yeah.
And the answer is no. And this is why it's not wrong to ask in a case like this what we ask in ground 1, which is, does the mere intimation of a defence bring with it? Let me start that again. Does the intimation of a defence which might be arbitral in one context, I'll put it like that from at the moment, because I accept that the question of the validity of the supply contracts could be an arbitral issue in some context. Does the intimation of that sort of defence by a defendant render the claims to which it is said to be a defence a matter in respect of which the proceedings are brought falling within Section 9, if that defence is impossible as a matter of law to amount to a defence and cannot evidentially support any element either of the cause of action or of the defence? And the answer in my submission is obvious, but it was entirely skated over in the analysis of the court below.
But what if it was evidentially supportive?
Well, then different considerations apply, my lord, and one gets into the question of whether an evidentially relevant defence, which might in some contexts be arbitral, either renders the claims against which it is raised themselves matters that are arbitral.
Well, that would be taking it too far, wouldn't it? I mean, I can't see any reason why, just because something's evidentially relevant, it drags into the arbitration agreement.
Well, that we entirely agree with respect. But that's the argument against us, that even if you can eke out some evidential relevance of the supply contracts, because they say, well, if it turns out they were very profitable and nice contracts, then it undermines the suggestion they were dishonest. I say, well, that's not open to them as a matter of English law, but let's assume that somehow that does come into the equation. If the claims we bring otherwise are not matters in respect of which we have agreed and must be required to arbitrate, why does the introduction of an evidential matter that happens to relate to a contract with an arbitration clause drag those claims from the court, where they belong, we say, into an arbitration?
Well, it can't be within the scope of the arbitration clause just because it's a matter of evidence.
Yes, well, we respectfully agree.
Or it should be a legal issue.
We respectfully agree, but there is a debate. If it matters, the defendants suggest you're wrong on that, my lord. Now, the reason it doesn't matter is because we're not even in the realms of evidential relevance in our submission at this point. We're in a world where it genuinely might be said that if a defendant comes along and says, in response to my bribery claim, I want to raise a bribery claim in relation to the guarantee of a transaction under which I bought my house, I want to raise a clause we had, an issue in relation to a contract we had relating to the car you bought 10 years ago, because I want to prove that was honest. And by the way, that's got an arbitration clause, and therefore your claim's got to go to arbitration. That's the sort of realm we're in. And it's a proper comparison. It would mean that defendants could raise any defence, and the whole lot gets pulled out of the court into arbitration. Even on the mere assertion of relevance, and even on the mere legal relevance, and even on the mere assertion, it would seem, on my learned friend's case, of evidential relevance. And the cases which we may come on to look at, my lord, I'm focusing on my Lord Hamilton's question, do engage with this concept of evidential issues, peripheral issues, substantial issues, and so forth. Both at the stage one is trying to define the matters in respect of which the proceedings are brought for Section 9 purposes, which is the methodological question that you have to answer before you then ask whether those matters have to be arbitrated. But secondly, my lord, also in a sense, in the way my Lord Legate has suggested, at the second stage of the analysis, which is, well, can they have been intended by rational parties to require arbitration in the context in which they arise? And if they're merely evidential, our submission is no, clearly not. And there may be a gradation of relevance that you could get to with certain issues.
So you seem to be saying that in order to be a matter which has to go to arbitration, there needs to be a distinct dispute between the parties which is capable of legal resolution.
Yes, and of relevant legal to be relevant to the legal resolution of the case. Yes.
Yes. Yes.
And what is perhaps surprising is we'll come on to ground 2 of the appeal. There's actually quite a lot of common ground between me and my learned friend that Section 9 is looking for the essential elements of the claim or defence. And they do go some way in their written case to accept that non-essential elements of the cause of action or defence are not matters in respect of which proceedings are brought. What is curious is that the allegation remains that these legally irrelevant points are in fact the very matters that do drag the other claims into the arbitration when otherwise they wouldn't be there. So, can I go back to the Court of Appeal's judgment, my lords? We were at paragraph 98. The second sentence of 98 says, the Republic cannot avoid the conclusion, that's to say that the matters are brought in respect of the validity, etc., of the supply contracts, simply by referring to the scope of what it is necessary for it to establish its claims against the Privinvest companies without the IFA, as opposed to the scope of the issues naturally arising as a result in the proceedings against the Privinvest companies as a whole.
Why don't you look at it claim by claim?
Well, yes, is the answer, my lord. One can and should, but you'll see, I hope, in there that there is a first of all, there's a strange acceptance, I would submit, that when you look at the scope of what it is necessary to establish our claims, the supply contracts don't form part of them. That's the first half of the second sentence. But the judge then seems to say that even if you've established your claims, and those are matters that aren't arbitral matters, you still have to look at issues as a whole that will be raised, even if they can't or don't or won't have any legal relevance or evidential value in that exercise. And that is also in
what exercise?
The exercise of establishing your claims against the defendants. In other words, the first half of the second sentence, my lord, is about...
Yes, I mean, the trouble with a very general proposition like this is that it can break down depending on the situations you postulate. So if you have a claim by A, which B says has been settled, and the settlement agreement is subject to arbitration, well, the point made there in the second sentence would seem to have considerable force, wouldn't it?
But more force, perhaps, my lord. But I think
I think you say it has no force so far.
Well, the debate one would have at that point, I suppose, is whether it's necessary to establish your claims to take into account the settlement clause. And the cases suggest that in a settlement agreement type case, there is a particular potency to an arbitration agreement or a dispute resolution agreement, because it's clear that most parties settling claims will intend it to have the widest conceivable.
I was postulating one where the very claim made by A is said by B to have been the subject of the settlement agreement.
Yes. Well, I'd venture to suggest that you're right to some extent, my lord, but it does depend on how you read the first half. Because I mean,
that's a different point. I think
yes.
I think a sort of general attack on the second sentence goes too broad.
Well, I'm content with that. I don't need a general attack, but the point is as I submit, flows from 96 and 98.
But to establish the claim, you've got to overcome any defence.
In a sense, that's right, my lord, and that's why, in answer to Lord Richard's question, I was equivocating, because if the defence is you have compromised the cause of action or discharged or released it, then in a real sense you can say you failed to establish your case if there's a discharge. Whereas in our case, the judge appears to be postulating that we can establish the bribery claim, but that...
It depends how broadly you read it. I mean,
well,
if you take what is necessary to establish its claims as just the elements of the cause of action, then you can surely have a situation where then the defence that's made which would defeat the claim, brings the whole thing into the arbitration.
Yes, and one sees that, rightly, as my Lord Aldrich says, especially in the settlement cases. But of course, one has to be careful. It always depends on the wording of the clause. Now, having decided that the validity and commerciality of the supply contracts is therefore a matter in respect of which the proceedings are brought, as my Lady Justice Carr does, at paragraph 99, you see she then turns to whether that dispute is a matter within the scope of the arbitration agreements. And that's the second element of the Section 9 test. And her ladyship decides there that it was indeed sufficiently connected because it relates directly to the SC, the supply contracts, raising a dispute as to their validity, genuineness and commerciality. And that, with respect, does not flow when one assumes that there can be no dispute about a legally irrelevant matter. In paragraph 100, the judge says that the defence arises in response to every cause of action pleaded, in a very summary and, with respect, perfunctory fashion, without any analysis of how so. And I've explained that we take issue with all of those. And the operative conclusion is then reached at paragraph 101. The result is that all of the claims against the Privinvest companies are matters which fall within the scope of the arbitration agreements, objectively construed, that is what the parties are to be taken to have intended, acting reasonably in good faith. And that makes it clear, my lords, that the matters the Court of Appeal considers are the matters in respect of which the proceedings are brought under Section 9, it appears, are each of the causes of action, as well as the IFA, which I'm going to come on to in a moment, as a separate issue.
So did the Court of Appeal decide that all the claims fall within each of the arbitration agreements?
Well, we're going to come on to that, my lord, because there's no analysis as to which claims against which parties fall into which arbitration agreements, and that's one point that I will need to develop with your lordships, because
Mr. Justice Waxman saw that as a problem in taking a broad interpretation of the arbitration clauses.
It arises in two respects, my lord. The first is the one your lordship identifies, quite right. That's a matter of Swiss law on which Mr. Justice Waxman's findings are not impeached. The second reason it arises is because you may remember from my written case, those tables with the ticks and crosses.
Yes.
Shows you that each arbitration clause has got different parties, and each arbitration clause relates to different of the three transactions. And there is no attempt to analyse, and I want to develop this more in a moment, why, for example, a claim in respect of the pro indicus guarantee, for which transaction, in a broad sense, D6 was party under the supply contract, could possibly arise and fall within the only arbitration agreement to which D8 was a party, which is the MAM supply, which was entered into 18 months later. And those sorts of issues, which you might call the permutation or parties issues, are entirely untouched by the Court of Appeal. There is no analysis of how that works.
But the order they made was a general one, wasn't it?
Yes. So, in a sense, it is that every way we make our case against every defendant falls within at least one of the arbitration agreements, and we don't know which one or more it is said they fall within.
Yes. So, one of the oddities is that at first instance nothing goes to arbitration. On appeal, everything goes to arbitration, yes. And there may well be a middle ground.
Yes, but more specifically, if everything is going to go to arbitration, one needs to analyse which arbitration agreement the particular claim against the particular defendant goes to arbitration. Not least because in this case it matters, because some of the arbitration agreements are governed by under the auspices of the Sky Swiss rules in Zurich.
And others are
ICC in Geneva.
Geneva, yes.
The experts agreed they were incompatible as a matter of Swiss law, which means you can't consolidate arbitrations under the rules into one arbitration. And different things therefore different things will result from the analysis of whether this claim against that defendant falls within that contract or not.
But even if you could consolidate, it doesn't necessarily get around the problem as to what was the scope of the individual arbitration.
No. My learned friend's answer to this point with respect, is merely to say, well, it doesn't matter, it's not practice, it's a practical issue. But that's not the answer. That is not an acceptable legal analysis. And moreover, it's not a practical answer, because if you end up with different results depending on who's in which arbitration, one ends up with estoppels arising against certain parties only in one arbitration, but not in another. One has the problem of arbitrations moving ahead of each other potentially, and estoppels being arising where there is a commonality of parties in one arbitration but not the other, and then again as it applies to the court proceedings. Anyway, the point is, my lords, that the analysis of that sort of problem is lacking.
Yes.
And I might make the point, and while we're here, just on the page with paragraph 102 in front of you, that my lady, in fact, overrode a concession that the Privinvest claimant defendants did make, both at first instance and in the Court of Appeal, that the unlawful means pleaded at 133.2 of our pleading, that's to say Credit Suisse's entry into the guarantees with its guilty knowledge, the court decided was actually an arbitral matter that was required to be arbitrated along with the rest of the conspiracy claim, even though, A, as I said to you earlier, that particular has absolutely nothing, that unlawful means has absolutely nothing to do with the supply contracts and cannot, and secondly, it was conceded. But what my lady doesn't deal with is the other concession that the Privinvest respondents have made, which was that 133.6, the sixth unlawful means, the deceit claim, was also not an arbitral matter vis-à-vis Privinvest. Now that had been conceded by Mr. Calver at first instance. Perhaps if I just give you the reference to that, it's at page 326 of the transcript, where he says that both 133.2 and 133.6 do not relate to my client and obviously wouldn't be referred to arbitration. But not only, we'd understood, I think, it's fair to say, Mr. Matthews on the appeal as conceding both 133.2 and 133.6. The Court of Appeal only overrode that concession in relation to 133.2. But in my submission, both are clearly not matters within the scope of the arbitration.
So it's not addressed by the Court of Appeal in this passage?
Point 6 is not, Madam, no. But again, if one is to postulate a conspiracy in which those two allegations were the only unlawful means, it is impossible, in my respectful submission, to see how that could fall within a clause in a supply contract that has no legal relevance to those claims. So, in summary, the crucial part of the judgment here is has several analytical problems. I suppose one would say, in my respectful submission. The first is that the court characterised Privinvest's reliance on the validity and so forth of the supply contracts as a reasonably foreseeable defence, without analysing how or to what extent it actually is a defence in law, or is capable of being, and it's not. It also ignores the fact, as I've mentioned, that it is not in fact Privinvest's defence to the claims, as actually now pleaded out in extenso, because it does not raise the supply contracts in defence to the tortious bribery claims at all. Secondly, the court does appear to conclude without any analysis that the issue of the validity of the supply contracts is itself a matter for the purposes of Section 9, because you'll see at paragraph 96, as I showed you, the court uses the very language one sees in the Singapore Court of Appeal case of Tomalugan to identify matters in respect to which proceedings are brought by reference to whether they are substantial and not peripheral or tangential. And that's the very language her ladyship uses in paragraph 96. So it appears that she is finding that the proceedings are in fact brought in respect of the validity of the supply contracts. And that we particularly challenge as ground 2 of our appeal, but consciously the issues overlap to a degree. And the third analytical problem with the Court of Appeal decision is that it assumes that if a proposed defence is itself an arbitral matter, and I think the court would understand we use that in the sense to mean a matter that has to be arbitrated. under the proper scope of the clause. The court appears to assume that if a proposed defence is itself an arbitral matter, it necessarily operates so as to drag the entire claim to which it is said to be a defence into an arbitral stay under Section 9, even when that claim might otherwise not be. And again, respectfully, we criticise the Court of Appeal's decision because there's no analysis as to why or in what circumstances that will occur. Still less, of course, why that would occur in the absence of any identified legal relevance of the arbitral matter, the putative arbitral matter, the intimated defence. And certainly no analysis of the context in which that matter arises and whether it is, if it's only evidential, for example, it is a context that requires to be arbitrated as opposed to being dealt with as a tangential issue in the court proceeding. So, with that, my lords, can I come on to the IFA and the concession, as I promised my lord I would?
But just going back there, but if it was a substantial matter, then the analysis would be correct. It was on proper analysis a substantial matter.
Not entirely necessarily, my lord, because there are substantial matters that arise that are not arbitral in every context in which they arise. And you'll see that in the canal, the Panama Canal case, which I may come to, but the ACP and Sakir case. There was no dispute in that case that the arbitral matter was a substantial one. It was the underlying primary debtor's liability, I think, in a guarantee case. And the very issue arose as to what that liability was. And it was said, and I think accepted by both parties, that it could be a substantial issue. But there was in that case a debate about whether the claim needed to be arbitrated if it was brought under one contract, which was governed by English law and English court jurisdiction, as opposed to a contract in which the very same substantial issue arose, which was governed by arbitration between the same parties. And in that case, it was decided that even though it was a substantial issue, it was not the matter in respect of which the court proceedings were brought. That was the liability under the court governed contract. And therefore it didn't have to be stayed, even though it was the very issue that would arise in a different context and require to be arbitrated in that context. So, my lord, that's a long way of saying there are some substantial issues that do not fit the analysis of the Court of Appeal because of the context in which they arise. But in general terms, it's probably right to say that if it were a substantial issue that went to a legally relevant defence, and it infected, if you like, the claim to a substantial degree, then it could well be a matter that has to be arbitrated, depending on the terms of the clause.
Chief Justice Menon's distinction between substantial on the one hand and peripheral or tangential on the other must be by reference to the legal claim that is in the courts.
Yes, I think that's right, my lord, if I may say, as a in all cases. But overlaid onto that analysis, as you'll see from the Panama Canal case, is the question of whether in the context it actually arises in the case, it is genuinely to be said, even though it's substantial, to be the matter in respect of which the proceedings are brought. And I don't perceive that problem or that issue will arise in this case. It may be something we don't have to.
I think the point I was making, I think, was more supportive of you than against you. In that one would, what you're saying, I don't know the Panama case, but no doubt I can look at it. You're saying in respect of one claim, it's a substantial issue because it's relevant to that claim.
Yes.
In respect of the claim in question, in that context, it may be it isn't a substantial issue because it's not relevant to that claim.
No, it was agreed to be a substantial issue, and it was of the highest relevance because no liability would flow against the guarantor, except for the amount of the primary debtor's liability, which was the substantial issue.
Right.
But it was it was recognised that that substantial issue arose in the court proceedings, but also would arise in an arbitration under a separate contract where the same issue arose between the same parties.
Right.
And so it's an example of a case where you can have a substantial issue, but the context means it's not the matter in respect to which proceedings are brought.
Well, perhaps you can just give the reference to the reference to the Panama case. I won't take up your time.
No, I'm grateful. If I have the time, I'll help your lordships more particularly on that. But if in the meantime, can I refer you to, first of all, our written case at paragraph 65 to 66, but the authority itself is at 1727.
Thank you.
And I think I say in writing pretty much all I want to say about it. So I'm happy to come back to it if it assists. But that was a long and painful way, I suppose, to answer my Lord Hamden's question, which is, in most cases, it's likely that a substantial, if it's properly substantial, but a defence, a genuine defence, then in many cases it may well operate to bring the whole claim into an arbitration, subject always to the wording of the clause. And I say that because there are particular issues on this case as to the wording of the clause, which mean you can't make any assumptions about it, and I'll come on to deal with that shortly. Now, I'm dealing with the IFA and the concession then specifically. It is true, I've shown you that we have pleaded against all defendants that each of the supply contracts was an instrument of fraud. And you see that, for example, at para 64 of our pleading in relation to Pro Indicus, page 427 of the bundle. And this allegation is repeated across the pleading in relation to all three supply contracts.
It doesn't seem a very analytically rigorous allegation, if I may say so.
Well, my lord,
I mean, on one reading of it, it's alleging that the contracts were sham, so they weren't contracts at all. But then the other reading is saying that they're not commercial contracts, but that's not a legal cause of action. The fact that it was at an undervalue, it's merely an evidential matter, perhaps in support of some other legal issue.
Well, with respect, we agree. I should agree to the last point. I'm in the lucky position of not having pleaded this, and I'm defending someone else's pleading. But
well, it's usual as the leader in those circumstances to take responsibility.
I absolutely do. Yeah, my lord, the Republic stands behind the allegation. But I accept that it is analytically a complex amalgam of points, because it goes to not only the possibility it's a sham, as you say, which is a hard legal concept, I suppose, but it also brings into play issues about the nature of the price paid and the services rendered and the bribes paid for it. Now, the reason it does that, my lord, if I may say, does have an analytically rigorous and sensible purpose. And that is because it is primarily part of the case against Credit Suisse and its knowledge of the circumstances in which this transaction occurred. And I don't need to develop that, but essentially, the case against Credit Suisse, as you'll see in the pleading, fundamentally different from the ways one puts it in bribery and conspiracy, but in terms of the validity and voidness of the guarantee and the ostensible or actual authority of the people signing the guarantee, the Mr. Chang, this is primarily directed to the point that Credit Suisse should have been on notice that there was something off with this transaction, if I can put it at that level. But my lord, I don't need it to be analytically rigorous or not rigorous, and in fact, if it is analytically not rigorous and is in fact just an amalgam of evidential points, then it rather suits me, because it shows that it's not a substantial legal issue and it can be conceded safely as we have done. The one aspect, my lord, where it does arise as a legal issue is in the conspiracy claim as an unlawful means. And this is what we've described and has been described as the UMIFA, the unlawful means instrument of fraud allegation. Because, as I showed you, I hope you'll remember when I showed you paragraph 133 of the pleading, page 442, one of the 6 unlawful means that we have pleaded is the use of these instruments of fraud in the transaction.
Well, then that just brings one back to in what way that itself is an unlawful matter.
Yes, it does.
It all seems to be there as a sham allegation, which I can see that is an allegation made, but usually it's rather The whole point of bribing someone is to get a contract under which you get money, not to pretend to have a contract.
Well, my lord, what I can say, what the debate centres, if I may say, on whether whatever the legal analysis is of that pleading, in other words, whether it is an unlawful means in law or it is not, whether our having made it and our having now disavowed it for the purposes of this application somehow changes the outcome of this of the case of this application. Because it is said against me that having pleaded that these supply contracts were instruments of fraud, including, if you've noticed, the little particular one of that allegation, that they were procured by bribery, that we can now not get away from the fact that our case is all about the supply contracts, and it infects all of our bribery and conspiracy case, irrespective of this particular of unlawful means, so that, in truth, it is said against us, this case is really all about the supply contracts, and that means it has to be arbitrated. That's the nub of the debate between the parties. Now, this allegation has survived in its present form with some tweaks and amendments in the latest version of the re-amended pleading. But it is very important, my lord, as I hope I've shown you, to note that the legal relevance of it vis-à-vis Privinvest is singular. It is merely, as far as our claims against Privinvest are concerned, one of those unlawful means. And there is no other legal relevance to the IFA of any description in respect of any of our claims against Privinvest. We don't need it to get home on any of the other causes of action, in bribery or conspiracy and so forth, as I've told you. And even if Privinvest were to set out to disprove it as an allegation, it would not assist them in defence of those allegations. My lord,
but you plead the supply contracts were obtained by bribery.
As part of the IFA.
That's all part of the IFAs only?
Yes. I think we plead that the transactions were procured or tainted by bribery, and it said, well, that includes the supply contracts. In an indirect way, perhaps that does.
So you're saying that there are various allegations here that only go to your IFA case, but it might be helpful to identify exactly what they are. That's what you're saying. Because I think the pleading makes that clear, does it?
Well, perhaps you could think about it.
Perhaps I can come back to that
over the short adjournment, and if necessary, give us a note of what they are, because you're conceding that those matters are arbitrable, are you not?
We are within scope. Or we are not resisting that they're within the scope of the contract. Now, the idea is to excise any debate about what our case is about the supply contracts vis-à-vis Privinvest. If I haven't gone far enough with my concession, then the pro tanto stay that we are conceding may have to extend to something else.
Yes.
And if it's said, well, you can't say that the transactions were tainted by bribery because you've defined transactions to include the supply contracts, then I'll accept a stay to the extent that includes an allegation about the supply contracts. What we've tried to make it clear is that we will not be advancing against Privinvest, assuming we are even parties to the arbitration agreement, any case that depends in any way, legally or forensically, on the validity or otherwise of the supply contracts. And that, I apprehend, Lady Justice Carr understood by the opening words of paragraph 95 that I showed you, or 96 I should say, I showed you, when she accepted that, in a sense, we've effectively removed the IFA from the claim. Now, can I just make the point, my lords, that it is now admitted by Privinvest that the singular legal relevance of the IFA is in that third ground of the unlawful means conspiracy. And it could be rather important, and it's not something that hitherto has been clear. But if you look at paragraph 205.1 of the defence at 554, this is where Privinvest pleads to the IFA in the Pro Indicus contract. Of course, one has this in relation to all three transactions. And it is, in a sense, my Lord Legate's points are made, that it's not understood what this allegation is as a matter of law. That's at 205.1, page 554. It's said at 205.2 that the relevance of the allegation is unclear. And then at 205.3, which is the important point that I'm on, page 555, the relevance of the allegation is therefore limited to the allegation that the entry into the Pro Indica supply contract constituted an unlawful means for the purposes of the Republic's conspiracy claim, as we clarified in our response. And it is denied that it is capable of amounting to an unlawful means, which may also reflect your impression, my Lord, Lord Legate. Now, that is therefore the limit of the IFA as it applies in relation to Privinvest. Admitted it is of singular relevance only to that unlawful means. And we concede, to avoid debate, and I argued this and succeeded in the first instance, but to avoid the debate, I have conceded, without getting into it any deeper, that we will live without that allegation, the third limb of the unlawful means conspiracy. We can treat it as having come out of our case. Now, if that is so, then the unlawful means conspiracy that we are now able to advance against Privinvest does not include the objectionable unlawful means ground 3.
The current pleadings do, but you're undertaking to remove them, is that it?
No, well, my Lord...
It's a composite pleading against all defendants. That's a problem.
I thought your Lordship would ask me this. This is the problem we're in. At the moment, there are two reasons why we haven't just deleted it.
And that's because of that other it's relevant to other defendants.
It's relevant to Credit Suisse and all the other defendants, and Mr. Safa. And secondly, of course, it's not what you do in a stay application. In a sense, you can avoid a stay application by deleting. And one of the cases before your Lordships is Borlakova, and that's what happened in that case. It was alleged to have fallen in. There were allegations that were said to be arbitral, and instead of writing a stay, they deleted the allegation, and the court dismissed the stay application because it was no longer relevant. But in fact, if you're faced with a stay application and you have a claim, the stay operates to stay the issue or the matter, but it remains on the pleading.
Yes.
It's just the way it is.
Yes.
And I suppose if you win on the parties' point, it's in the
Yes.
again anyway. But
And that's why it's got a contingent relevance throughout, and therefore it has to sort of stay there. And I do respectfully understand why it looks strange.
Yeah, I see your point. Thank you.
But it is a matter of form, I
Yes.
would submit. The substantive effect of our concession, vis-à-vis Privinvest, subject to the parties' point, is that we make no case in the terms of the IFA or the UMIFA, and it is common ground that the UMIFA was the singular legal relevance of the allegation for that purpose. So it's gone. Now, in light of the time, I'm not going to take the court to it unless you'd like me to, but the Borlakova and Borlakov case, which is at page 1810 of the bundle, is dealt with in our written case at paragraphs 90 to 91. And if I could just describe to your Lordships very briefly, it was a case where a wife brought claims against the husband and very many other defendants for fraud, in respect essentially of the husband's attempt to dissipate all of the matrimonial assets before a divorce, so that she would have no assets in after the breakup. And one of the defendants who was sued was the protector under a Panamanian, I think, foundation, and the foundation documents included an arbitration agreement. And so it was said that any claim against the defendant who happened to be the protector of the foundation was arbitral under the foundation documents, and essentially that was common ground ultimately. And you'll see that if you look at paras 367, 369, and in fact at 369 and 372 of that decision, the judge there applied this case in the Court of Appeal to the resolution of the outcome. That's at page 1866. So by the time the application came on, the claimant had accepted, in fact, that those allegations would be arbitral insofar as they were against him as qua protector, and it essentially both deleted things from the pleading and expressly pleaded these claims are not made against this defendant as protector, to try to make it clear that the situation was not going to trespass into arbitral matters. And that was held to be effective, and the judge, Mr. Justice Trower, effectively dismissed the Section 9 application because it was redundant after that. But, my lords, it's important to note, of course, what the claimant was doing in that case, and as we're doing in this case, is not admitting the contrary. One is not saying, because we accept that an issue might have to be arbitrated, and therefore we're dropping it from our claim. We're not admitting that the opposite is true. And just as in that case, the claimants no doubt were not admitting that this man did not act wrongly when he was the protector. But my learned friends seem to suggest that because we're not going so far as to admit the supply contracts were bona fide or genuine, commercial and profitable, that we are somehow unable to disavow a claim that may involve that issue. We say that can't be right. So, my lords, we do say in summary that although we haven't deleted them, and we can't really delete them, it won't make sense practically, that is the way in which the Court of Appeal rightly considered the matter to have been dealt with, as I showed you. And we can and do, must now make our claim against Privinvest, assuming we are parties to the arbitration agreements, without the IFA and the IFA, and we will do so. Now, it's no answer to that point, my lords, to say that whilst there's no legal requirement to link bribes to specific contracts, one can't sensibly, I think it is said by the Court of Appeal and by my own friends, one can't sensibly divorce the bribery in this case that we say led to our potential liability under guarantees from bribery that did in fact, or might in fact have, procured the facility agreements or the supply contracts. Now, that is true on one level, because we don't admit that there was no bribery in relation to that could have possibly tainted the supply contracts. Of course, we don't admit that. But that's just a matter of the factual background, a statement of the facts. It doesn't say anything about the actual matters in dispute or the matters in respect of which the proceedings are brought as a matter of legal analysis. Can I just posit a potential example to your lordships? If you consider a case where the conduct of the defendant alleged would constitute, undoubtedly constitute, a breach of 3 separate contracts. The factual allegation is such that if proven, there would be inevitably a finding of breach of 3 separate contracts. But only the third of them contains an arbitration clause, the third in time, perhaps. And the claimant only actually claims damages under the first contract, because, I don't know, maybe that was the only one that actually ended up being loss-making, or whatever. Now, there'd be no getting away from the conclusion, as a matter of factual context, that the allegation of breach, the wrongdoing, if you like, that was being alleged, included a breach of the third contract. But if the claimant disavows any claim for breach of that contract, or any claim that relates to that contract, then that fact cannot bear, legally or relevantly, on the matters in respect of which the proceedings are brought. It's just a fact, a contextual matter. And for similar reasons, of course, one can allege breaches of contracts against one defendant in a claim, but not against another, because there's an arbitration only against the other. One could never concede that there was no breach in such a situation, because you need the breach to make the case against the first defendant. But to say that you're alleging a breach which would amount to a breach of another contract cannot possibly mean that that allegation of breach has to be arbitrated. And that is, there's nothing artificial or contrived about that. The tenor of the criticism in the Court of Appeal against us, and by my learned friends throughout, has been that we are artificially trying to separate off the guarantees from the supply contracts, when it is inevitable, they say, that the same bribery will have tainted all of the contracts. Now, at a factual level, it is, maybe inevitable is too high, but it's probable that it did. But our point is, so what? There's nothing artificial about a claimant choosing to focus its claims in one direction rather than another. We're not doing it to avoid the arbitration clause. We're doing it because the arbitration clause doesn't bite on the claims against the defendants in respect of the guarantee losses. So one has to be careful about the idea that it's all very artificial. And in fact, insofar as there's a choice involved by a claimant in our position, of course, we're in a similar position in some ways to the claimant in the Panama Canal case, where there was a choice to sue either under one contract with an English court jurisdiction clause in respect of the same issue, or an arbitration in respect of the same issue. It's not artificial to say, well, you're choosing one over the other. That's just a choice. And of course, importantly, we're in the position, my lords, of, on our own case, saying we cannot sue under the supply contracts. We are not party to them. The whole arrangement was set up to mean that we were not parties to them. So when you're looking at what case we have and whether it's artificial, you can't take the assumption that we might be parties, which is the underlying legal assumption, and hold it against us as creating an element of artificiality, because that's not why the assumption is made. Now that's why, going back to the defendant's case...
Well, it will be assumed, won't it, or treated that the contracts were valid for the purpose of the claim, because there's no claim being made to rescind them.
Yes.
Even if they were affected by bribery and were voidable, they haven't been avoided, and therefore they are valid contracts within the context of the proceedings.
Yes, and that's why where my learned friends fall into error again, because the so-called defence of the validity, etc., of the supply contracts doesn't engage with the question of whether they were tainted by bribery, because of your lordship's point. They were valid and will remain valid and have remained valid.
Subject to the genuineness argument, but that you're cutting out of
we're cutting that out,
purposes.
And that means it won't arise against best defence. Yes, that's right. So when can I just take your lordship back on that point, therefore, to the para 75 of the respondent's case? It's in hard copy at 104 and electronic at 125. There it said the claim is founded in substance on the allegation that the payments, the bribes, were paid to procure the supply contracts. That is the way it has to be put against us.
Paragraph, sorry?
75, my lord.
75, thank you.
This claim is founded in substance on the allegation that payments were paid to procure the supply contracts. Now, that is simply untenable. But the fact that we have to have, the case has to be mischaracterised in that way is telling, because that's the only way it's going to get my learned friend anywhere in Section 9. And so he's talking here actually about the claim, the bribery claim in particular, in fact. Now, whatever wiggle room those words in substance are intended to introduce into that sentence, they do not get you far enough to say that in substance our claims are founded on anything to do with the supply contracts. And were they so founded, and I accept that there was an argument at one stage that the third element of the unlawful means conspiracy was such an element, then that has been removed by virtue of the concession.
Sorry, can you give me that reference again, please? Paragraph 75.
Yes, my lord. Paragraph 75, page 125 of the electronic bundle, or 104 of your lordship's document.
Thank you very much.
And are the footnoted references in footnote 81, or they're all IOF?
IFA. Yes, my lord.
Yes.
They are the IFA allegation. So you can see what's happening in a sense is that the concession is being used as if it never happened, which was the very idea behind making it was to try to avoid the Court of Appeal actually having to bother address the appeal at all, but it clearly didn't work. And that's why if you go forward, my lords, or down the page on that page of one you're still on, to 76.1, that you can, contrary to what they say there, test the proposition by asking what hypothetically might have been pleaded. Because what you're really doing is analysing the fundamental allegations that are pleaded. So can I just perhaps posit that one can distill our case fairly and in substance, without artificiality, into these propositions, very short propositions. Firstly, Mr. Chang was in fact an agent of the Republic acting as such when he was involved with the guarantees. Secondly, he was secretly promised and or paid at least $5 million by the Privinvest defendants and or Credit Suisse, all of whom were jointly liable for it. And as a result, the Republic claimed the guarantees were void and unenforceable, or voidable, rescindable. Rescindable. We claim the bribe money in restitution, and we claim compensation in respect of any liability we might have under the guarantees if we're wrong about their validity. That is all we needed to prove, to plead, to make our essential bribery claim. And that, in my respectful submission, is the substance of our claim in bribery. Whatever other bells and whistles one finds in our long pleading, it is right to test the case like that, because when tested like that, one can see that the allegation that the supply contracts were valid, the so-called defence, is utterly irrelevant.
So all the other bribes identified in your schedule to other people, where do they go to?
My Lord, they go to the same... Let me start again. We know they are claimable in restitution, no matter whether a contract resulted or whether they were specifically had in mind a contract or whether they in fact induced a contract. So they go to that. They go, my Lord, because one can't sensibly, as a claimant in a position my client is in, disaggregate the corruption into payments that we can prove went to one contract but not another. We accept that. Now that's held against us in some ways as being a sort of argument why we must be impugning the supply contracts, because we can't prove that some bribes were not related to the supply contract. But you can test it this way, perhaps. It is a possible outcome at trial that yes, it is possible. I, of course, say it's highly unlikely, but it is possible at trial. We only show, in fact, that the constituent elements of bribery are made out against Mr. Chang, in respect of Mr. Chang. Mr. Chang, as far as the evidence goes, had nothing to do with the supply contracts, or at least it's potentially a conclusion the judge might reach at trial, that he had nothing to do with them. They appear to have had the principal involvement of a Mr. Dorizario, who we see received about $15 million. But it's possible, for example, that at trial the judge will find that Mr. Dorizario wasn't an agent acting as such, or that those payments were in fact not made, or that for any number of reasons, it is possible that bribes we say were paid to all of the various officials were or were not, are not made out. All that matters at the end of the day when analysing this claim is whether the essence of it, as I've identified in these three propositions, can be made out and is distillable from the pleading, which it clearly is. And whether, of course, we have a claim to restitution for the rest of the bribes. But what essentially is being said against us by the bribees, on the alleged bribers, is because you can't prove which of our corrupt payments really influenced which contract, you must be bringing a claim in respect of all of the contracts, and therefore you must have to sue as an arbitration. And you can see the highly unattractive conclusion that leads to, which is that it lies in the mouth of an alleged briber to say you can't disprove a connection to my contract with an arbitration clause, and therefore you must arbitrate all of your claims, even though the contracts have nothing to do with them. The claims have nothing to do with them.
We have the list in your particulars of claim of the recipients of the bribes. Do we have a list of who paid which bribes?
We do now in the re-amended particulars, my lord. Okay. Yes, right. I could just show you that, or give you the reference.
Just give me the reference.
You'll see that predominantly they came from two sources, right. And the reference is tab 15.19, Schedule 2A, electronic page. Getting there, sorry, my lord. It's now a very long schedule, 1205.
1205.
And it runs now over 4, I think, pages. And we can identify for some of the people who paid the bribes. They were predominantly paid by Logistics Offshore, which is the D9 entity. And
that's not a party to any arbitration agreement?
Not a named party, no. That's obviously one issue under the parties issue. And I'll come on perhaps now.
That's another assumption, isn't it?
It's now an assumption, but there is a difficulty with the assumption in that it's not clear which contracts D9 as opposed to D10 are said to have adhered to by this concept of Swiss law. It may not matter, but it's quite important if you're going to be analytical about the application of the arbitration clauses. So you see that logistics offshore is one of them, and then the other predominant source of money is D6, which is Privinvest Shipbuilding SAL, which was only party to the Pro Indicus supply contract.
And there are claims in restitution against them, is that right? The briber is liable as well as the bribee in restitution?
Yes, my lord, but it goes beyond the actual payer in the sense we allege they were all jointly liable.
Or can they be jointly liable in restitution or just in damages for conspiracy? Or?
We say in both, but it may not matter, but it certainly arises clearly in restitution, to which there's no obvious defence in my submission, as directly against the payer. We may be wrong about some of these payers. I'm not entirely sure that we are saying that these are proven.
It may illustrate the point. Privinvest Shipbuilding SAL, did you say that was a party to one of the contracts?
D6, my lord, Pro Indicus only.
Pro Indicus, right, yes. So would a claim against Privinvest Shipbuilding SAL be 6? In respect of a bribe which led to that particular contract, fall within the agreement?
No, we say no, because certainly the restitution claim has no connection whatsoever to the contract.
It led to it.
Well, it may or may not have led to it, my lord. We don't allege that it did.
I see.
And quite importantly in that respect, can I make it clear?
I thought you alleged that you don't allege that it did at all?
No, not against Privinvest.
It just led to the guarantee?
Just that it tainted the guarantee. Because there's no requirement to prove a causal link between a bribe and a contract at all. The only question for restitution, well, the contracts are irrelevant for restitution. For loss, I accept you would have to show that loss was caused by the bribery, and the normal there is a strong presumption in English law that the amount you paid for your contract was inflated by the amount of the bribe, and we say therefore the amount of the guarantee liability was inflated by the amount of the bribes.
Your point is that the facts, if proved, may well, or most certainly would, give claims relating to the particular contract, but those aren't claims you're making.
Yes, exactly, my lord. Yes, quite. Right. And of course, certainly for the tortious claims, they are made jointly against all of the defendants, including Credit Suisse. And there are some in that list you'll see, my lord, which we identify as Privinvest because we don't know who paid them, and we don't know whether they'll be proven to have been paid at trial. For example, to Mrs. or Madame Chang, who was, I think, the wife of Mr. Chang. But there's an important point that arises out of all of that, which is that on a Section 9 application, the respondent, or the applicant under Section 9, Privinvest, have to prove on the balance of probabilities that the claims brought against them fall within the arbitration clause. And as you know, that is a final decision this court has to take, or the English court takes under Section 9, whereas some jurisdictions just adopt a sort of prima facie case and leave it to the arbitrators to decide whether they're actually in scope. But the point there, my lord, is that if we don't allege a connection between any of these bribes and any particular contract, my learned friend's positive case is that there is no connection between the contracts and the bribes. You'll appreciate that it is the essence of their defence that they were not paid to procure any contracts. They were paid for genuine consultancy services and political campaigns. So if we're not alleging it, my learned friends eschew it as an allegation, in fact positively deny it. How can they establish, on the balance of probabilities on a Section 9 application, that there was any connection between the bribes and the contracts?
If you don't allege it and they don't allege it, where is the bribery?
I'm talking, my lord, specifically about
there isn't for those contracts.
There is bribery,
yes,
but we don't allege it by dropping the IFA and the UMFO, we're not alleging it was linked in any particular way to the supply contract.
I see. Well, you're not saying it was linked in any particular way, but you're not saying it wasn't.
No, but we bring no claim. We're not saying it wasn't, but that's a pretty understandable position, I would hope, my Lord. But because we're not saying it was, none of our legal claims depend on establishing that it was.
Yes, I see.
The applicant who's got the burden of proving there is a sufficient connection has a positive case that there isn't a connection.
So you say, well, if the Privinvest Shipbuilding payment, the first one,
yes,
was as much relevant, or for your purposes, was relevant to the guarantee.
Yes, and in fact, my Lord...
And that's all you care about.
That's all we care about, but not just the guarantee. As I mentioned, Privinvest Shipbuilding is D6. It was only party to the Pro Indicus guarantee.
Well, that was the first one.
Yeah, which was the first one.
Yeah.
We allege that D6 is liable in bribery for the liability we may suffer under the MAM and Imartum guarantees too.
And that depends, at least to some extent, on the fact that it did actually make payments.
It did, yes,
as it were, after the Pro Indicus agreements.
Yes. But we infer that there were promises made earlier. But the point for present purposes, my Lord, is that D6 is not a party to the Imartum and MAM transactions in any way, shape or form. And it goes therefore back to my Lord Hamblon's question, which is that even if you could prove, even if it was possible on their case to run a case that there was a sufficient connection between D6's bribery and Pro Indicus, to which it was a party in the supply contract, said, what is the case that is being made as to why D6 is liable in bribery for procuring the MAM contract, guarantee, or supply contract? Because D6 wasn't a party, is not alleged to have been a party. And as I'll show you, Lordships, the MAM arbitration agreement expressly says it is not connected to the other contracts. So this is a level of analysis that I'm afraid one will neither has to grapple with or accept the Court of Appeal simply didn't entertain. All of which is to say that the Court of Appeal's decision is unsustainable, and one is left with Mr. Justice Waxman's perfectly sensible and unimpeachable analysis, if I may say, which did grapple with these sorts of issues. Can I just... sorry, my Lord.
Yeah, it's fine.
Can I just... I suppose it's a punchline to the submission I've been making at some length. If I show you what the defendants say at paragraph 20 of their case, so paragraph 1, it's in your hard copies at page 79 of the bundle, and it's in electronic versions at 100. It's para 20, subparagraph 1 of my learned friend's written case. He says there, the Republic's case boils down to 4 main propositions, none of which assists it nor identifies an error of law in the judgment. First, that the Republic's claim is brought to recover its losses under guarantees, not the supply contracts. This is nothing to the point because, and then this point, the Republic's claims against the Privinvest defendants can only succeed if the Republic establishes its case on corruption in respect of the conclusion of the supply contracts, including that they represented part of a conspiracy. And then 2, there is no part of the Republic's claims against the Privinvest defendants whereby the Republic can somehow establish that the guarantees were tainted, even if it fails to establish that the supply contracts were tainted. Now that is at the very heart of the misconception we say is in the case and in the Court of Appeal's decision, because we have no case on corruption in relation to the conclusion of the supply contracts now that we've dropped the IFA and the UMIFA. So we can't set out, and therefore we can't fail to establish, that they were in fact tainted by corruption. But even if that were not so, that paragraph can't be right, because bribery tainting the guarantees may, as a matter of fact, may as a matter of context, also taint the supply contracts if the relevant agents were acting in the right capacities in relation to the dealings for the other contracts, which is the point I've made about Mr. Dorizario. But so what? It's a peripheral irrelevance to the legal claim that we make. I should say, apart from the fact that it might be said that at trial we we do succeed in establishing all of the elements of bribery in relation to the payments to Mr. Chang, don't succeed in relation to Mr. Dorozario, who was the one who signed the supply contracts. That's one possible theoretical outcome, which means that the two bribery claims do not go hand in hand and aren't inexorably linked. But a similar outcome might be that, for example, Mr. Dorozario was only proven to have been paid bribes or promised them after the first contract had been entered into, but before perhaps the second or third, or after the first two, but before the second and third. It's perfectly possible. In those situations, the fact that we would not have a claim, were we to want one, in relation to Pro Indicus and Mr. Dorozario and the supply contracts, can't possibly mean that we're not allowed to make a claim in court in relation to the bribery of Mr. Chang that we say undoubtedly did induce or did lead to the Pro Indicus guarantee and all of the other guarantees. So that even if it were legally relevant, which is not, and even if we set out to prove that the supply contracts were tainted by bribery, which we don't, it is not inevitable that one follows the other anyway. That's all a matter for trial. Now, can I make a start just on dealing with specific points that arise under what we've called ground one? And as your lordships will know, that what I've said so far is, in a sense, it's essential context and very much part of the argument for both of the grounds as they work out in the legal analysis. But I want to just look at ground one specifically, which is the issue of whether an intimated defence that is or could be in one context arbitral renders the entire claim to which it relates arbitral. I can take this fairly quickly, I think, because it appears to be common ground between me and my learned friend that there is nothing automatic about the intimation of a defence that is or might be arbitral and the rendering of the claim to which it relates arbitral. I think it's common ground that one has to analyse the context in which the issue arises, as well as the scope, the wording and meaning of the clause under its proper law. There's clear law and authority, albeit at first instance, for the proposition that raising a defence that is certainly arbitral is not necessarily going to make the claim itself arbitral. And that's the T&N case of Mr. Justice Lloyd, which you've got in your bundle at 3165. And we cite these relevant propositions and references at para 102 of our case. But it's that decision of Mr. Justice Lloyd and the decision in China Export of Sir Richard Field, as he'd become, that's at bundle 1950. Those show that you can have, and sensibly have, an arbitral defence that does not render the claim arbitral, and it effectively leaves the defendant to elect whether to fight it in court or litigate the defence in arbitration and take that course.
Mr. Spobwell, as he then was, disagreed.
He to some extent disagrees. Yes, I think he distinguishes those cases. In fairness, my lord, and we would distinguish those from Ruhan, as we call it, because it's easier to pronounce than the claimant's name, because Ruhan is a settlement case. And it's very much in the line of those cases that my Lord Richards was positing, where you've got a wholly different set of presumptions about the width of a settlement clause, of an arbitration agreement in a settlement clause. But there is a tension there, my Lord, between those and perhaps Ruhan, but they're distinguishable because of the settlement aspect. But it doesn't really matter. We're not arguing at first instance, of course. What we're looking for in my submission is the principle behind all of this and where the court is left. The second reason the Court of Appeal's apparent principle, the apparent approach that an arbitral defence ipso facto drags the claim with it, why that can't be right is, of course, it can't accommodate the established principles relating to transactional set-offs. We deal with this in our case at paragraph 114, page 84 of the electronic bundle. I'm not going to go through all of that, but your lordships will be aware that in a case where a claim is brought in court and the defendant raises a defence by way of a transactional set-off that would normally or might normally be arbitral, not only does that not mean the claim has to go off to arbitration with the defence. But in fact, it's a very firmly established principle that the claimant cannot get a stay of the arbitral matter raised by the defence under Section 9. And there are various ways of analysing that. I think my Lord Hamblin analysed it, we would say properly, one of the first instance decisions he decided, as being, on proper analysis, a transactional set-off is just are not proceedings brought by way of a counterclaim. They may be under the heading of a counterclaim, but they're not in the nature of proceedings brought by way of a claim or counterclaim so as to engage Section 9. And we would endorse that. The other approach is to say there's been some kind of waiver by the claimant, but that's a rather more problematic approach. So it's contrary to that sort of principle, which again, although it's described by my learned friend as a black swan, it's a very firmly established principle, and it arises not uncommonly. But the real reason that the court can't be right about this arbitral defence dragging everything into an arbitration is because it's contrary to principle, quite plainly contrary to principle, because it all depends on whether the parties are to be taken to have intended by the words they use in their clause, in the context in which it arises under the law that governs it, whether one or both or neither the claim and defence are in fact to be arbitrated in those circumstances. That, I think, is common ground between my learned friend and me. But it's an important aspect of analysis, because unless you do that analysis and actually ask yourself, in a situation where the Court of Appeal ended up, where it considered there was a defence that was arbitral, instead of saying, now we need to construe the parties' intentions to understand whether in this situation, in the context that it arises, everything has to go to arbitration or nothing has to go, they simply said everything goes, without any of that crucial analysis as to the parties' intentions. And one can start that analysis very easily, of course, and one can show the Court of Appeal was certainly wrong with respect, because it is not just highly unlikely, but actually almost impossible for commercial parties to have intended that the raising of a legally irrelevant defence that was arbitral would somehow make the whole claim against which it is raised arbitral. And yet that is the very outcome achieved by the Court of Appeal's decision. And if you're going to go down that route at all, of course, you'd have to somehow analyse why it is that the one follows from the other, and there isn't any. And even if one can then approach it, my lords, by asking whether the intimated defence, which is presumptively arbitral, is slightly more than irrelevant, or slightly more relevant than irrelevant to the claim, and one would approach it on a sliding scale of relevance. And one would have to ask in each case, according to the relevance of the issue to the matters in respect of which the proceedings were brought, whether the issue engaged by the defence that would or might be arbitral means the parties must have intended the whole of the claim and the defence to be arbitrated. And that is a matter of analysis that is quintessentially one for the first instance judge, who hears the evidence, especially in a foreign law case like this, who hears the evidence as to what the foreign law, how the foreign law would approach an arbitration clause, has all of the evidence of the context in which the agreements were made, where there's a multiplicity of contracts, and applies the foreign law to the presumptive intentions of the parties, because the degree of relevance will inform the outcome of that analysis. And it gets much more complicated and, dare I say, nuanced than that when you have multi-party, multi-contract cases like the present case. Because, first of all, you have to analyse relevance as a matter of law. I've mentioned that. Secondly, you have to analyse context in the sense that there are some substantial important issues that are arbitral but still not subject to Section 9 in the Panama Canal sense of that I mentioned earlier. But thirdly, because you have to, in a multi-party, multi-contract case like this, you have to analyse very carefully the legal relevance or connection between the alleged defence and the individual defendant who is applying for the stay in the context of whichever contract or contracts that individual defendant is party. This is where we come back to the point we were discussing about D6 being the bribe payer and D6 only being party to pro indicus. Because, can I take this example? If D8, who is the only Privinvest defendant who was a named party to the MAM transaction, if D8 were to establish, as they wish to do, that the MAM supply contract entered into in mid-2014 was a valuable, commercially priced, valid contract, possibly even in the Republic's best interests, or whatever, why would that inform the analysis of whether the parties to the MAM arbitration agreement, that's D8 and on this assumption the Republic say, why would it inform the question of whether those parties intended a claim by the Republic for loss resulting from the other two contracts, the earlier Pro Indicus and Martin contracts of guarantee, I mean, of course, which is the only source of our liability? Why would the parties to the MAM supply contract have intended that that dispute be arbitrated under the MAM contract? And conversely, if D6, who wasn't a party to MAM, was only a party to Pro Indicus, wanted to assert the honesty of the MAM supply contract as part of its case on honesty or whatever, even though it wasn't a party to it, which appears to be what they want to do, that couldn't conceivably be something arbitral under the MAM supply contract because D6 isn't a party to it. And so you'd have to then engage in analysis of how the parties to the Pro Indicus contract, to which D6 was party, somehow intended their arbitration clause to be engaged by disputes as to bribery inducing the MAM arrangements 18 months later. It's that sort of analysis that you have to go through. And of course we say the further and further you get away from claims against the defendant who is the party in the relevant supply contract, in the relevant transaction, the further you move away from that, the less and less obvious or the less and less possible the connection is.
That was Mr. Justice Waxman's approach,
yes,
in saying that the multiplicity of parties and contracts was an important context when you were measuring sufficiency of connection.
Yes, and in a way it is, but it's not just a factual question of sufficiency of connection, but it's an analytical question of how you tie that to the parties' intentions when you've got to look at the parties to that particular clause. That accompanies my mind.
Would that be a convenient point to take the short adjournment?
It would.
Thank you very much.